Before I call roll to establish quorum, I will provide a detailed information on how this meeting works. This meeting is being held via teleconference and webcast on Friday, April 24th, 2020. Board members are attending telephonically. I will ask board members and staff to mute their telephones to eliminate background noise, and when they are ready to speak, they can unmute their telephone. I will take roll call of each board member for comments on each agenda item. If we need a motion, any board member can unmute their phone, identify themselves, and make a motion. If you are seconding a motion, please unmute your phone, identify yourself, and second the motion. I will take a roll call vote for each motion. Again, please identify yourself by name each time you speak so our audience knows who's speaking. This meeting is audio only, and the visual available is the webcast information screen. We are taking public comment on each agenda item, and if you wish to provide public comment, please email your comments to bvmpboard@dca.ca.gov. Please include the agenda item number so your comment is read at the appropriate time. You may direct your question or comment to a specific person. If you're providing public comment, your name is not necessary. And please indicate how you would like us to identify you. There will be a pause after each agenda item to allow time for email comments to arrive. I will ask board staff if they received any comments. The EO will read the question verbatim and state the name of the sender or the sender's email address. If there's more than one question addressing the same point, the EO will then read the names of the other senders into the records before moving to any additional questions or comments addressing other points. For the sake of efficiency, the EO will respond directly to questions posed to her or defer to the appropriate staff person or counsel for questions directed to the board members. I will either answer the question or direct it to the board members. Please note all emailed questions and comments will be attached to the official minutes of this meeting. I will now do an alphabetical roll call to establish quorum. I will ask each board member to respond here after I say their name. Paula de Amazola de Herrera. Here. Bernice Bass de Martinez. Here. Alita Carpenter. Here. John Durking.
Here.
Ken Maxey. Here. Carol Mountain.
Here.
Donna Norton.
Here.
Where did I go now? Sorry. Paul Sellers. Paul, are you on the phone? Not hearing Paul. Melissa Rubacalva.
Here.
And Cheryl Turner.
Here.
Based on the roll call, we have established a quorum. Agenda item 2, now Elaine, can we have you announce who you have there with you?
Certainly. Thank you, Madam President. Elaine Yamaguchi, Executive Officer. With us, we have Marie Cordero, our Supervising Nursing Education Consultant. Mr. Tim Matsumoto, our Retired Newton Analyst. Candace Rainey, our Enforcement Chief. Jay Prouty, our discipline manager, Doris Piers, our legislative analyst, Vicki Lyman, our AEO, and Vicki Saavedra, our budget analyst.
Thank you. Who just joined us?
I am present. I can hear. You can hear me, but I am present.
Oh, sorry, Paul. So, agenda item 2 now. I ask you to please recite the Pledge of Allegiance with me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Liberty and justice for all.
Thank you. So we're going to be doing the special board meeting today. Elaine, I have one question. Since we've done roll call, okay. I'm going to have all board members introduce themselves. My name is Tammy Mendoza, and I'm the LVN board member and the current board president. So if we could have board members introduce themselves, starting with Paula.
Hi, this is Paula Amazola de Herrera, public member.
And then Ms. Bernice.
I'm Bernice Basta Martinez. I'm a public member and also vice president of the board.
Alita Carpenter, public member. And then John, if we could have you introduce yourself.
Yes, thank you, Madam President. John Dierking, public member.
And then Mr. Maxey, Ken.
Yes, Kenneth Maxey, public member and chair of the enforcement committee.
Thank you. And Ms. Mountain, Dr. Mountain.
Dr. Carol Mountain, I'm the education member.
Donna.
Good afternoon, Donna Norton, LVN member.
And then Paul.
Paul Sellers, psychiatric technician, member.
And then Ms. Rubicava.
Hello, Melissa Rubicava, psychiatric technician, board member.
Good afternoon, Cheryl Turner, public member.
Thank you. And legal counsel, if we could have you introduce yourself.
Thank you, Madam Chair. Kenneth Swenson, senior staff counsel, attorney 3, general counsel for the board.
Clay Jackson, attorney 3, regulation counsel for the board.
Thank you. So we will move on to, do board members have any questions or comments that they'd like to say before we start with board business? Paula?
No comments at this time.
Alita?
No comments at this time. Thank you.
Bernice?
No comments at this time.
Ken?
Just a comment. I just wanted to thank you and Vice Chair Dr. Bath Martinez and, of course, the staff for all the work that they're doing, particularly during this pandemic of COVID, and all the nurses and students that are going through the challenges of this virus. Thank you for all the work that you're doing at BB&PT.
Thank you. Carol?
No comments. Thank you.
Donna? Paul?
No, not at this time.
Cheryl?
Yes, I'd just like to thank all the healthcare professionals who are putting their lives on the line to look out for us and provide care to patients. Thank you.
Thank you. And then I myself would like to, Tammy would like to thank the staff for all the hard work they're doing. I know this is a difficult time. And those that are actually working from home, thank you for all the work that you're doing. Because I know it's very difficult to be at home and try to have a dedicated space to actually do some work. So thank you for all the work you're doing. That brings us to review and possible actions on regulations to implement AB 2138, Agenda Item 5. Elaine, if you'd like to provide us an update.
Thank you, Madam President. Elaine Yamaguchi, Executive Officer. As the board will recall, AB 2138 amended a number of sections of the Business Professions Code about how boards like ours could respond to applicants with criminal convictions. And this bill generally removed board authority to deny an application based solely on formal discipline by a licensing board. There have been a number of back and forth, so if you do feel that sense of deja vu, yes, we have had have a variety of different versions of this language come before the board over the past year. And to provide some detailed commentary on the changes, the substantive changes in this version that we hope to go forward from the version that the board approved most recently, I'd like to defer to Mr. Jackson.
Thank you. Can everybody hear me? Hope so.
Yeah.
Okay.
Yeah.
So let's just go through the LVN version, the vocational nurses version. The differences that are between the original text that was adopted by the board and revisions that was adopted by the board and what we're currently talking about. The new stuff is double underlined or double strikeout. So depending on how big your screen is, you may or may not be able to see them. A lot of these changes were done at the request of OAL for specificity issues, and they wanted to make sure that in looking at a particular text, for example, if you look at 2521A, you'll see the first revision where it says or section 2878 of the Business and Professions Code. And there they want to make these so that they are profession specific as opposed to just being general. You look at the addition there of section 141, and they want to make it specific to the ends. If you look separately at the PsychTech one, that one would have the PsychTech code for their code section on that. So they want to really drill down so that when they're talking about substantial relationship to a profession in what the crime or act or whatever may have been, they want either a layperson or a regulated person to be able to pick up this reg and be able, or this regulation, and be able to say to themselves, okay, this is going to apply to me by looking at the specific section that relates to me as a regulated person. And so you'll see that. Moving to B, the small b, or in the original text, it had said subdivision, and divisions are in code sections, so the Business and Profession Code discusses they would be subdivisions. However, since this is regulation, these are subsections. So you'll see several revisions in B and C of both sets of regulations where subdivision is just changed to subsection. And so it's not moving around, it's just better clarifying where these revisions are. OAL does not like the phrase "but are not limited to," despite the fact that I don't think there's an attorney in the world that doesn't use it. So they made us get rid of "but are not limited to" in C. Scooting down, a lot of the remaining revisions, and the revisions here are highlighted along with being double underlined or double strikeout so that you can see them better. And some of the stuff is just grammatical, changing periods to semicolons or the other way around. So there's that. And then if you look at what I call shopping lists, for example, C has got the shopping list of all those crimes and acts that were added. At the end, most of the time when you have a shopping list or whatever kind of list you want to call it, you'll put "and" just before the last one. And I keep saying OAL does not like that format, so we got rid of that from here. And then the reference section, the authority and reference, we listed the additional Business and Profession Code sections that are being added per 2138 so that it's more consistent with other 2138 regulations that are being put forth. So that's 2521. Moving on to 2522, a lot of the same comments. The big difference between this regulation, prior regulation, and the Psychiatric regulation is going to be in 2522A, where it crosses out 2787.7 and replaces it with 2878.7, because the original citation is just wrong. And somehow someone with dyslexia like me, but luckily this one wasn't me, at some point it was put inadvertently improperly in the code. So when I was going through checking the code sections that were cited, I found this, and so I've changed it to the appropriate code section. And we'll go through in the final statement of reasons and just explain this change. So this is the only true substantive issue that is at all different from the mirrored versions in the Psych-Tech regs. So that's why that one's being changed, because it's the wrong regulation. And I don't believe that 2787.7 even exists, which was kind of a clue I needed just to keep looking for something else. So going down to "and is presently fit for a license," OAL didn't like that phrase, so it was just better if we just took it out, so we agreed that we would take it out. And a lot of these revisions were considered non-substantial by OAL, so they didn't they didn't require either a 15-day comment period and other technical things that would have been necessary, but staff felt it was important to just throw all of these in for your review, opposed to the revision in B, which is considered a substantial revision, and so the part that starts, if an applicant has not completed the criminal sentence, we struck everything below there in that paragraph from if subdivision A is inapplicable down to the rehabilitated in the colon, and we replaced it with what you see underlined there. That was specifically requested by OAL, and if you're at all into English, you'll note that where it says if subdivision A is inapplicable is a lot like where it says based on the criteria in subsection A. So a lot of it was just moving stuff around and being, again, more specific and using words that they liked better. And again, we used your regulation section there to put 2878 in. So again, more specificity moving down to the list. Severity, for some reason, was changed in Section 482 of the Business Professions Code, and for some reason, the word severity wasn't good enough for whoever wrote AB 2138, so they changed it to the word gravity. So we have that. We have professional misconduct, which was added in this set of regulations, as opposed to unprofessional conduct, which is currently in your regulations, which is used predominantly by every board that has unprofessional conduct. But for some reason, 2138 felt it was necessary to create a phrase that's never really been used in the law, which is professional misconduct. So now we had to go through, we created the regulation to better define what professional misconduct was. So you'll see that there in B1. So it now has nature and gravity of the crimes, professional misconduct, or acts under consideration. And we weren't able to point back to the unprofessional conduct that has been in your regs for a long time. So these revisions are somewhat awkward to the extent that we're kind of shoehorning in language that's never been in your regs before, and we're shoehorning things that aren't really in the law elsewhere into your regulations. So that's why you see things, and severity is just another word for gravity. So unless you're talking about some Newtonian theory. So again, these are just really minute changes, but they were caused because of those regulations. Any questions?
Yes, this is Cheryl Turner. Where did you say the definition for professional misconduct is located?
Well, that's the problem. Is it's not really defined. And when I went and did a search for the phrase professional misconduct, it's not really even found in the Business and Professions Code. It's found in regulation in, I want to say, a statute related to attorneys. Mm-hmm. So it's just something that somebody, I'm not going to say the legislature got sloppy because that would be rude, but somebody liked this term better than unprofessional conduct, so they put it in. Because as you'll note, it's new in every one of these sections. It's brand new, and it's brand new in the Business and Professions Code, essentially. And so it's here. We're dealing with it by making this regulation, but it's not really defined except for in the new business and profession code sections, and we're not really allowed in writing regulations just to basically take the business and professions code and mirror it into your regulation. So we're basically stating it. It goes and it does talk about in 480. It does talk about professional misconduct, but we really couldn't just copy it into your regulation, because then it would be duplicative of the existing law, and OAL frowns upon that. Because the purpose of a regulation is to further define, make clear, and to allow the regulated public to be able to better understand what the Business and Professions Code is doing for the profession, and this allows better regulation through better understanding. And so there really isn't. There's nothing to define, because except for citing, unless we went in and cited attorney, the attorney stuff, and where lawyers have talked about it and judges have talked about it related to lawyers, it doesn't exist related to psych techs or vocational nurses.
So then does it make sense to use the term, or do you want to allow argument by either side about what it means?
We have to use the term because 480 has the term in it. The term was added to the law, therefore we have to put it in. But we're essentially using in stating what professional misconduct is. We're basically, if you look at 2521, and we added it there, professional misconduct, and then below there, under C, there's your that's as good a definition as we had. And then staff went to because if you look at C, for purpose of Section A, professional misconduct or act shall include. And then it goes through and it lists 1 to 6 that were originally in your regulations, and then staff felt it important to add the first time around. So it's new, the 7 through 13, which are in many of the other practice acts, and it's going to end up in many of the other professions regulations. Because there was 2 ways to go. There was just basically leave it, I'm going to say fluffy, and not define what professional misconduct was, or give these examples. Mm-hmm. And so staff felt it more important to give better examples so that someone that's regulated or that's looking at what a regulated person did or would do can look at this and say, okay, I probably shouldn't do all of these 13 things. And so it is there, but it's not shall only include. And they may just get rid of or not limited to, but it's not just those things. So
okay, I see. It's clear to me now. Thank you.
Yeah.
This is Denise Basti Martinez, and just a follow-up on your explanation there. From your legal viewpoint, if a petitioner were to have attorneys who would argue confusion based upon the new definitions, where would you point them? Is this clear enough so that board decision is definitive and would not be taken issue based on legalese or the way it's written?
No, I don't think there would be a problem, and this is what OAL has requested, and they've let this. I can't say they've let it through because on November 17th, it was agreed that VetMed had to pull their regulation. To date, what are we now? 5 months later, VetMed is still not been finalized. Neither has any of the other almost 40 boards or bureaus been finalized. So there's not one DCA reg that's gone through saying this language is absolute and we could all use it. But because OAL hasn't had a problem with this in anything they've reviewed so far, neither has agency or executive, DCA executive, we feel comfortable with this, that this is okay. And Ken might have something to add to. But I have no problem with the way this is written.
Ken Swenson here. I concur with Mr. Jackson's analysis and do not consider the language to be problematic in any way with respect to enforcement matters.
Thank you very much.
And actually having specifics in there will allow somebody to essentially get a clue as to what they're not supposed to do. If you leave it without these examples, somebody's going to say, I had no clue, because how am I supposed to look at just C that says for purposes of this shall mean, professional misconduct shall include the following, and you don't give anything following, then they're left to their own devices to figure it out. And these are very specific things, and you still also have your unprofessional conduct. So we didn't get rid of your unprofessional conduct and then put in professional misconduct. Now you've got yet another tool to use, which is professional misconduct, although still kind of up in the air what it is. So you're okay.
So this is Cheryl Turner. So basically the definition is found, or at least examples are found in section 2521C for LVNs.
Right, and then the corresponding PT section.
Okay, thank you.
Thank you for the update.
You're welcome.
I'll do a call of board members for any questions. Paula, do you have any questions for Clay or Ken?
No, thank you so much. That was a great summary.
Bernice, do you have any further questions?
No further questions. Thank you very much.
Thank you. Alita, do you have any questions or comments?
I did, but thank you, Clay. You did an excellent job clarifying my confusion.
You're welcome.
Thank you. John, do you have any questions or comments?
No questions or comments.
Thank you. Ken, do you have any questions or comments?
Not at this time, no.
Carol, do you have any questions or comments for Clay or Ken?
No comments or questions at this time.
Thank you. Donna, do you have any questions or comments?
No, thank you.
Paul, do you have any questions or comments?
Yeah, I think I have one question. I just want to clarify something. When I read through the 2522B, is that saying that essentially this professional misconduct applies equally to applicants as it does to discipline of current licenses? Same criteria?
Really good question. As you'll note, the shopping list is different. And the reason why is because what you can require under AB 2138 from a new applicant is different than what you can look at and require from an existing licensee. So you're really not allowed to ask about specific crimes, and this is going back forever. And I'm going to give an example that came from one of your board meetings, I believe in October, and there was a lady. She had lost her license and was seeking her license back, and she came, and during the hearing, it came up, and this lady was probably in her 50s, and she'd done everything she'd been asked to do, and one of the questions related to a DUI that she'd had back when she was 18 years old, so 30 years before, and the question was fine. It was perfectly fine. And up until then, I personally had a problem with 2138 because I think, my personal feeling was all criminal conduct should come out, and then the board should be able to completely decide what applies and what does not, and make a ruling from there. However, when I heard this lady and listened to her entire speech and all the changes she'd made and everything that she'd done since she'd lost her license, including getting, I believe, 2 master's degrees in social work and counseling, and then a question about a crime that was 30 years before was asked, I thought, okay, it's relevant, but if 2138, if these regulations had already been in effect in 2138 and 480 that doesn't come into effect until July 1st this year, that question wouldn't have been asked because you wouldn't have found out about a 30-year-old crime, even though back then it would have applied, because the purpose of 2138 is to allow the board to make the same decisions, but use relevant current data. So that lady never would have had the question asked because it would have fallen out of the 7-year period that you can look back under 2138. Whereas now, because it hasn't come into effect, that question was fully appropriate. And until then, my eyes weren't open to that aha moment of this lady could have used 2138. She could have used the new law, and she, I believe, I wasn't behind closed doors, but I believe it was a, unanimous decision to give her back her license. So anyway, the rehab criteria is what she would have applied to her because she was seeking to reinstate her license. So 2522, long answer, but 2522 would use those 13 items. And if you use the example in your head of what I just discussed, it would apply really well. And so it is different than what you would be looking at under somebody that was just seeking their first license under 2521. Does that answer the question?
That does, but it brings up one hopefully a quick follow-up to that, which is then with a discipline, not seeking the license to be reinstated, nor an applicant, but somebody under discipline. Are they limited to the 7-year rule there?
A lot of it depends on the crime, because and that's, if you look at substantial relationship and the other one, nature and gravity of the offense, number of years elapsed since the date of the offense, and some of these never wash out. Okay, murder never will wash out on any of these questions, on any of these regulations, or the code sections. Aggravated assault will not wash out. And I can't say that sexual crimes can't, because they're is a way to get those off your record, but so they are not required to report. So if you look, for example, at 2521C8, conviction of sexual offenses requiring a person to register as a sex offender pursuant to 290 of the Penal Code. If they're not required to register under 290, there are some sexual offenses that would wash out. Okay? But if you look at 9, that's the one I was previously discussing. So there are things that you will be able to look at. The 7 years will not apply to, and those were a lot of the things that we listed and put on the shopping list for 2521C, so that those would definitely be brought up. It gives you a better opportunity to look at and judge whether or not somebody should or should not become a licensee.
Excellent. Thank you for the detailed answers. I appreciate it.
You're welcome.
Sorry. Thank you, Paul. Melissa, do you have any questions or comments?
All of my questions have been answered. Thank you so much. No questions here.
Thank you. Cheryl, do you have any further questions or comments?
No, thank you. No further questions.
Thank you, Cheryl. I have one, but let's say this would be a licensee who had a DUI that resulted in some sort of accident that has ended up having to serve time, and then come out of that and they want to reinstate their license. Would that, and then the time span was over 7 years that they spent in prison, how would that reflect in this?
Ken, since you're a criminal expert, do you want to take that?
Thank you, Ken Swenson here. It would depend on the specific crime charged. And so if it was something like vehicular manslaughter, it would fall within what can be considered. But it really depends on the charge and the particulars of the case. So it's a kind of hypothetical that's hard to answer in the abstract without knowing the particulars of what is presented.
So ultimately, basically, it has to be in one of these little slots to be considered.
That's correct. It has to fall within the criteria themselves.
And it could fall under your unprofessional conduct. Like I said, these are so close but different. It could fall under a completely different set of regulations that you've already got in place. So this is just yet another tool. And what I was talking about earlier when I said somebody can wash their record, that would be under B11, under 2522 B11, where somebody could go, and there's a whole other discussion that I don't want to get into today, but somebody could go and dismiss their conviction, which means their entire record would be purged. And so that's why in B11 it says, if applicable, evidence of proceedings to dismiss a conviction pursuant to Penal Code Section 1203.4. So someone could actually go, and whether it's getting a dismissal, whether it's getting the governor to take action to remove their crime in some way, all of those things are also possible which would then add to Ken's answer of it depends on what the crime was. And then you add 11 to that, and if they'd cleaned up their record, that crime never existed. So you couldn't even look at that crime.
Okay, thank you.
Cheryl, so just to be clear, once this goes into effect, if they have a dismissal of that conviction, we cannot consider it?
Once it's dismissed, and there's a difference, because another thing that this does is this looks at convictions, because prior to 2138 you could look at arrests and say this person was arrested 10 times for selling prescribed drugs, or which is definitely a violation of every nursing practice or every psychiatric practice out there. But if they got it dismissed, it never happened. And just because you're arrested doesn't mean that you've committed the crime. It just means that you've been arrested. So 2138 took those and got rid of the ability of boards and bureaus to look at those, because it's essentially unconstitutional to hold someone with charges that they were never convicted of. And so that is something that the legislature wanted to get rid of, and they did.
Okay, so I'm only asking about a dismissal of a conviction, not
right. And here under 11, that's why it says, if applicable, evidence of proceedings to dismiss. So if it was applicable, the Attorney General could bring it up if it was applicable in the specific case. And if it's not applicable, they wouldn't be able to. And which is why you'd have a Deputy Attorney General and Ken, who was a Deputy Attorney General, working together on every reinstatement in order to make sure that, if possible, they would get the evidence in front of you.
Okay, not to continue with this for too long, but okay, this relates to the evidence, but what about the actual dismissal of a conviction? Can that, if the conviction comes before us as an issue, my question is are we supposed to consider that or not if it is dismissed? The actual conviction itself, not necessarily the evidence, but the fact of a conviction.
Ken, why don't you take that one too?
Ken Clinton here. Once the regulation is adopted and under the authorizing statute, you would not consider the fact of the conviction once it has been dismissed.
Okay. Thank you. Thank you.
Madam Chair, if you're ready at this point, I have a recommended form of motion that I can provide.
If you could, that would be great.
I would recommend as follows, and by the way, I'm recommending that each of these sections have a separate motion so that there's no confusion about what is being accepted and adopted. So the form of the motion for the first one would be that I move to accept and adopt the revised regulatory language of Section 2521 of Title 16 of the California Code of Regulations relating to substantial relationship criteria for vocational nurses, and to submit the revised regulatory text to the Office of Administrative Law.
Ken, do you mind repeating that again?
Certainly. I move to accept and adopt the revised regulatory text of Section 2521 of Title 16 of the California Code of Regulations relating to substantial relationship criteria for vocational nurses, and to submit the revised regulatory text to the Office of Administrative Law.
Okay. Is there?
This is Donna. I will move whatever Ken just said.
John Deerking will second.
Okay. It was moved by Donna and seconded by John. What Ken recommends as the motion. Is there any public comment? If you wish to comment on the agenda item, please send an email to bvmptboard@dca.ca.gov. So we'll wait a few to see if any questions or comments come in.
Madam President, we have not received any public comments or questions.
Okay. So it has been moved in second, and we will do a roll call vote. We'll start with Paula.
That my vote is yes.
Bernice.
Yes.
Alita.
Yes.
John.
Yes.
Ken.
Yes.
Carol.
Yes.
Donna.
Yes.
Paul.
Yes.
Melissa.
Yes.
Cheryl.
Yes.
And I'm a yes. So motion carries.
Madam Chair, I likewise have the recommended motion for the psychiatric technician regulation that I can read.
Okay, thank you.
The recommended motion is as follows. I move to accept and adopt the revised regulatory text of Section 2578 of Title 16 of the California Code of Regulations relating to substantial relationship criteria for psychiatric technicians, and to submit the revised regulatory text to the Office of Administrative Law.
This is Donna. I'll move it.
John Deerking will second.
Thank you. It's been moved in second. If there's any public comment, please send the email to the bvmptboard@dca.ca.gov. Elaine, has any comments or questions come in?
Madam President, we have received no public comments or questions.
Thank you. So it's been moved in second. I'll do a roll call vote. Paula?
Yes.
Bernice?
Yes.
Thank you. Alita?
Yes.
John?
Yes.
Ken?
Yes.
Carol?
Yes.
Donna?
Yes.
Paul?
Yes.
Melissa?
Yes.
Cheryl?
Yes.
And I'm a yes. Motion carries. Thank you.
Madam Chair, Ken Swenson here. I have a recommended form of motion relating to the rehabilitation criteria revisions for vocational nurses.
Okay.
The recommended form of motion is as follows. I move to accept and adopt the revised regulatory text of Section 2522 of Title 16 of the California Code of Regulations relating to rehabilitation criteria for vocational nurses, and to submit the revised regulatory text to the Office of Administrative Law.
Okay.
This is Donna. I will move Ken's motion as stated.
John Deerking will
Thank you.
second.
Thank you. So it's been moved in second. Is there any public comment? If there is, please email to bbmptboard@dca.ca.gov.
Madam President, we have not received any public comment or questions.
Thank you. So we'll do a roll call vote. Paula?
Yes.
Bernice?
Yes.
Alita?
Yes.
John?
Yes.
Ken?
Yes.
Carol?
Yes.
Donna?
Yes.
Paul?
Yes.
Melissa?
Yes.
Cheryl?
Yes.
And I'm a yes. Motion carries. Thank you.
Madam Chair, I have a final recommended form of motion relating to the revised text for rehabilitation criteria for psychiatric technicians.
Okay.
The recommended form of motion is as follows. I move to accept and adopt the revised regulatory text of Section 2579 of Title 16 of the California Code of Regulations relating to rehabilitation criteria for psychiatric technicians, and to submit the revised regulatory text to the Office of Administrative Law.
This is
Thank
Donna.
you.
I will move Ken's motion.
John
Thank
Deerking
you,
will
Donna.
second.
Thank you, John. So there's been a motion and a second to move the regulatory language of PT in Section 2579. Is there any public comment? If so, please email to bbmptboard@dca.ca.gov. Elaine, has there been any emails?
Madam Chair, there have been no emails with any public comment or questions received.
Thank you. We'll do a roll call vote to establish motion. Paula?
Yes.
Bernice,
Yes.
Alita,
Yes.
John,
Yes.
Ken,
Yes.
Carol,
Yes.
Donna,
Yes.
Paul,
Yes.
Melissa, Melissa,
Yes.
Cheryl,
Yes.
and I'm a yes. Thank you. Motion carried. So that will bring us to agenda item 6A for discussion and possible action to determine how to conduct petitioner hearings at the May 21st through 22nd, 2020 board meeting. The board's enforcement committee met to discuss this issue and make a recommendation to the full board. I will call on committee chair Ken Maxey to report. Ken?
Thank you, Madam Chairman. So during our committee meeting, what we discussed was, and I know we've had this conversation before, fellow board members, but I think because of the current state of matters, it came to our attention from Elaine and team that we needed to move swiftly to ensure that this was not, something that we put off for some months. And so, Madam Chairwoman and I decided to vote yay on pushing this forward, and we ask for you all to also support, but definitely with a discussion if in fact you feel necessary. Did you have anything else to add, Madam Chairwoman? Hello? Is anyone on the phone? Hello?
Oh, sorry. I was on mute still.
Okay.
Sorry, Ken. This is a special time, and we wanted to continue to move the petition hearings forward. We didn't want them to be pushed back further. So that's why the recommendation.
So this is Donna. I have a question. So I can't, for some reason, the document won't download, but I looked at it before. So the actual recommendation is to send all of the petition hearings that would have come before us to a hearing, correct? That's the recommendation that's coming out of this.
Yeah.
I can't seem to download the document.
Yeah, so this would be an expedited process so that the AG's office would actually be making the decision. And this is a temporary solvent until we are able to figure out a more permanent way of going about this process.
So when you think of a more permanent way of going about this process, my understanding was that this was to deal with the current, while we're sheltering in place and we're not actually able to have people come before us, or are you speaking of an ongoing process that would stay in place even after this shelter in place is over?
Yeah, it's really TBD, board member. Only Donna, because right now we are, in a different state of approach, and so right now I think we're offering this as a temporary solvent, and then the committee will definitely entertain any more conversation moving forward for future conversations.
Mr. Maxey, if I could, Sully Yamaguchi, if I could ask our enforcement staff, Ms. Rainey, Mr. Prouty, to provide a little bit more color commentary, if you will, very briefly, I promise.
So yeah, I just wanted to add that while the cases will be sent to the Office of the Attorney General if the board does so vote for that move at this time, the board still retains authority over the decisions. Once an ALJ hears the case, he'll prepare a proposed decision that will then be sent out for board vote as any other proposed decision would. So you aren't absolving yourselves of any authority in this case by voting for this way. And it's only at this time, we're only specifically speaking of the petitioners that were scheduled for the May hearing.
This is Donna. Thank you for that, Jay. I can fully support doing this for the May hearing because we don't want to delay the petitioners, and we also, if we delay them, then that's going to affect the calendar moving forward. So I can 100% be in support of doing that for this time period. Long-term, ongoing discussions, I would reserve the right to have more input on.
Madam President, John Deerking here. I just have a clarifying question.
Okay.
So what is being proposed is that for this limited purpose, for the May meeting, the ALJ will be the trier of fact rather than the entire board. Is that correct?
Yes, for just the May. Ken?
Ken Swenson here. Mr. Deerking is correct. The administrative law judge hearing the case would be the trier of fact, make credibility determination, and write a proposed decision. The proposed decision would be subject to the same review process as proposed decisions in disciplinary cases. So the board would have the final jurisdiction. However, the actual hearing would be held before an administrative law judge rather than the board.
John Deerking once again. Thank you, Mr. Swenson. That's very helpful, and I'm very comfortable with the process.
This is Cheryl Turner. I have questions. If I can ask them now. All right, so I know that one of the concerns, or the major concern, seems to be that if we don't address these cases now, there'll be a backlog of cases. So I don't know if that, from my perspective, is important enough to overcome potential due process issues. I know that the courts of the state of California have delayed cases, extended deadlines, continued cases to give litigants an opportunity to have their day in court. So I know the ALJ is considered a day in court, but it would seem like that the board would, if we ruled on a written decision, we would be denied the opportunity to evaluate the credibility of the petitioner and to evaluate them. Sometimes we look at them and they may exhibit some things that might indicate that they're still, for instance, under the influence when we're dealing with a drug abuse case. So, Ken, you still believe that the petitioners would receive the exact same level of due process by referring it to the ALJ and having us rule on a written decision?
Yes, the statute itself, which is Business and Professions Code, Section 2878.7, Subdivision C, which reads as follows: the board itself or an administrative law judge, if one is designated by the board, shall hear the petition and shall prepare a written decision setting forth the reasons supporting the decision. So it's within the express discretion of the board whether to refer it to an administrative law judge or to hear it itself. And that's a policy decision. Obviously, if the ALJ hears the case, then the ALJ will be making a credibility determination. And that has to be given some deference, of course, because the board isn't observing the testimony or hearing the testimony live. So that's obviously a little different than normal procedure, but it doesn't rise to the level of a due process concern because the statute itself, and in particular the subdivision I read, is presumed to be constitutional, and it vests the board with the discretion to refer the matter to the administrative law judge. In addition, the Deputy Attorney General representing the people at the proceeding would have an opportunity to examine the petitioner about any issues relating to the petition itself or the underlying conduct. So it's permitted under the statute. It would be a policy decision for the board to decide to refer this particular group of petition hearings to the Office of Administrative Hearings. And it would not be a deprivation of due process, in my view.
Thank you.
This is Bernice Baston-Martinez. Following up, if I'm hearing you correctly, Ken, operationally, the individual would physically, in person, appear before the ALJ. Is that correct? Or am I misunderstanding? You know, since we're talking about being sheltered in place and the safety and wellness of all involved.
An ALJ? Is that possible? A lot of I know telemedicine is being kicked into high gear to be able to deal with this shelter in place. Have we considered that?
Actually, Mr. Chair, Madam Chair, if I may answer that, this is Elaine Yamaguchi. We have considered that option. We explored that. And because these petition hearings would not be held in a single day the way that we do with the board, they would be scheduled in and around the court's existing docket.
Have available and put an ALJ and a DAG and the petitioner in there, and then remotely observe and participate. Is that just too technically impossible to do?
Hey, Paul, this is Jay. I spoke with the Office of Attorney General discussing about this, and we felt that the logistics of getting every board member, an administrative law judge, a deputy attorney general, the petitioner, everyone on the same webinar or webcast, however you would call it, at the same time was just too logistically difficult.
I don't see why.
Okay. And then my last question is, I understand the concern with postponing the hearing is that we would potentially create a backlog. Is it we're only talking one day on August? Couldn't we add simply another day, a 3-day or a 4-day? I'm not sure what that's scheduled for, and just hear those 90 days and not jam up the rest of the schedule for 2020 and 2021? And again, reevaluating in 90 days if that's even possible.
Well, that was an option that was also discussed, but we felt that with the current uncertainty, we don't know when all the restrictions will be lifted, when we'd be able to add the extra day. We felt in looking at all the different options, this was just the most effective, efficient, and expeditious way to handle it at this time.
Okay, thank you.
This is Cheryl Turner again. I think I heard someone say that the ALJ conducting the hearings either telephonically or I'm not sure how. It sounded like telephonically. Is that correct?
That is an option, yes.
Okay. So if they can do it telephonically, why couldn't we? Or, and then going back to the use of webcams, there are a lot of different services that offer, that are available. Go to webinar, you know, we know about Zoom, and we know Zoom has some problems, but there are multiple things that are available. I mean, I just don't understand why we're not pursuing those to have these hearings, especially if the ALJ now is limited to the telephone. I don't understand. Well, yeah, I don't understand how that's going to be handled over the phone like that. So my question was,
all these options you mentioned, as I previously said, were considered. This was the one that we felt is the best at this time. That's why we put forth this recommendation. Obviously, you may not all agree, but we do feel that this is the best way to go at this point in time. The hearings may be telephonically. The petitioners could request to be heard in person, although actually, to be honest, we already pooled all 7 petitioners, and they all did say that they would agree to telephonic hearings at this time. If they changed their mind and wanted to be heard in person, then we would have to do that.
So, Jay, this is Paula Amazola. What I'm hearing is we can only vote on this recommendation.
Well, you can vote in support of this recommendation. You could vote against this recommendation. As I said, this is the one we're putting forward only for this May hearing and those 7 petitioners who were scheduled for May.
And have these petitioners been given the option to reschedule for the August?
Well, the August hearing is already booked, so there would be no rescheduling them for August unless we were going to push all the August people back to November, then the November people back to February, and so forth down the line.
This is Ken Swenson. I can add a little bit to what Jay had to say. Once the matters are referred to the Office of Administrative Hearings, the petitioner would have an opportunity to opt out if they so decide, and then the net result of that would be that they would be scheduled for the next available slot on the calendar for regular board meetings. But as Jay mentioned, in polling the petitioners, they've agreed to this procedure if it were implemented. And like Jay said, the committee itself studied the issue and came up with a recommendation to the full board that the May 2020 petition hearings be referred to the Office of Administrative Hearings for hearing before an administrative law judge. And so it's limited to the May 2020 petitions, and it was felt that was the most efficient procedure to follow under the present circumstances.
This is Donna. I have a follow-up.
Oh, sorry.
So this is Donna. I have a follow-up question then, because I guess my assumption was if we're going to refer them to the administrative law judge, that would be however they're going to do it. But am I correct to assume that this will get done before, this is going to be done within the next couple of months, so that we're not going to refer them to the ALJ and then have them sitting out there, and the ALJ is not going to hear them until November. Is that correct?
That's
correct.
Do you
have any control over that at all?
Right now, hearings are currently being scheduled. Even the ones that have been rescheduled because of the coronavirus are being scheduled through OAH into June and July. So we expect them to be heard before the end of July.
Okay, thank you.
Okay, since this is a motion from a committee, it doesn't require a second. If there's any further questions from the board, Paula, do you have any further follow-up questions?
Not at this time.
Bernice, do you have any questions or comments?
Only that it might be important to summarize what I thought I heard so that I'm not misunderstanding. But I hear the board members, one offering an alternative of running maybe 2 days in August, or, and I did hear staff say, we still don't know what the conditions will be around shelter in place. But after hearing that, one could assume that would mean, if not August, then at the next meeting that would be in person. I'm also wondering, since that was brought up, what my fellow board members think of having an emergency face-to-face meeting just for the purpose of hearings when we return or when things become get to the point when we're not sheltered in place. It's just a question, and it's what I heard. Maybe I'm misinterpreting the willingness of everyone to try to find alternatives. So that's it. I have no further comments.
Ken, did you want to answer that?
Are you talking to Ken Swinson or me?
I'm talking to you, Mr. Maxey.
Oh, I'm willing to entertain anything that is for the good of the group. We did not discuss that last part, Ms. Bass Martinez, in regards to an emergency meeting due to circumstances that I think are outside of our powers for the most part. But if it's up, if the will of the group is to do something like that, Madam Chair, I will leave it to them to make that decision.
Yeah. Okay. And this is Bernice again. Thank you, Mr. Maxey. I did understand that the committee did not, or that was not part of the recommendation. I was trying to summarize what I believe I heard us say in the conversation now.
Okay.
Thank you.
Thank you.
Thank you. Alita, do you have any questions or comments?
My main concern is that this all be conducted telephonically. I don't think you get an accurate picture of what's going on without seeing the petitioner.
Yeah, I do know that at least for a lot of the Board of Parole hearings that they just started redoing or started back up, they're doing them via a telemed visit via webcast. I don't know what they're using, but a lot of the other hearings and things that they've been doing, I know the BRN did send some of their petitioner hearings over to the Office of Administrative Hearings for April. And they were conducted via telephonically. But I share some of the same concerns as far as we don't get to see them, and due to everybody's different experiences, they come up with different questions. But in light of all of what's going on right now, being a part of the committee, I didn't want to see our petitioners have to wait a long period of time to be heard. And I know it's not the ideal way to do a hearing, but it also doesn't delay them too far down the line. So.
Well, I do understand that concern, but not only are we deprived of the opportunity to see the person, the petitioner, but the AG's office is also deprived of it. And I would think that this might have a bearing on their perception of the person and this situation.
I agree.
Madam Chair, this is Ken Swenson. I can point out that the Office of Administrative Hearings frequently hears matters telephonically. In addition, what's probably the largest administrative adjudicatory body in the state, the Unemployment Insurance Appeals Board, has gone to entirely telephonic hearings for all matters relating to benefits, and they did this prior to the COVID-19 concern. So the trend is for more and more administrative adjudications to be done telephonically. And the example of the Unemployment Insurance Appeals Board, I think, is an important one because they hear so many cases. It apparently has worked out well for them, and it's quite common even in court proceedings for some types of proceedings at least, to have telephonic hearings. So that seems to be more of the modern trend.
This is Bernice. May I make a comment? And it's an observation. The more things change, the more they remain the same. When we're really concerned about equitable review of all individuals, returning to a non-visual does, in some cases, stack the deck against the individual because of their diversity.
Yes, this is Alita again. I understand that concern also, but Ken, pursuant to your comment about the Unemployment Insurance Appeals Board, those people are not charged with the protection of the public.
This is Donna. I wanted to just weigh in here as well. I guess I was not understanding that the referral to the ALJs would be done entirely telephonically. I would have to echo what some of the other fellow board members have said. Part of what we're tasked with is determining whether or not a person has been rehabilitated, and we can grant them back their license to become a licensed vocational nurse or a psych tech again. I would be concerned with unprofessional conduct in such that in a completely telephonic interaction, you don't really know if you're even talking to the person. You don't even know if you're really talking to them. You could be talking to a neighbor. You could be talking to anybody that could somewhat speak better. I mean, I hate to think that would happen, but I think it could possibly happen. So I guess I wasn't understanding that it was going to be completely telephonic and that they weren't even going to use a Zoom method so that you could actually identify that the person that's on the phone is the actual person seeking to get their license back. Which again is very different than someone seeking to appeal the fact that they didn't get unemployment insurance. So I guess I'm not as convinced that referring them to the ALJ is as good an idea as I was in the beginning, when I actually did believe that it was going to be either a webinar or a Zoom or some type of visual interaction.
This is Paul Sellers. Can I weigh in a little bit here? I guess I'll set aside for a moment this notion. I agree with Donna that I hadn't even considered that through, and I'll set aside the idea that these are publicly accessible hearings. I don't know how that's going to be handled, but if and maybe I'm addressing this to Jay. My understanding is that this is going to be a telephonic hearing, that the ALJ is going to be present telephonically, the DAG is going to be present, the petitioner is going to be present, all telephonically. Somehow, though, we are not able to be there. We are currently telephonically holding a board meeting. All of us have those dates blocked. So I don't understand the technical limitation to having us part of this telephonic hearing if we choose to go that direction.
Yes. Well, we felt, and actually I should say that all hearings right now at the Office of Administrative Hearings are only being heard telephonically because of the COVID-19 situation. It was my opinion, our opinion, the opinion also of the Office of Attorney General that making the judge, the Deputy Attorney General, and the petitioner all available for a phone conference is much easier logistically than 11 board members, including those in the group. So,
aren't we all of these players, aren't they all already scheduled to be there in May? It's not like we would have to create a new date. That date's already blocked out. They're already selected.
Well, we don't know that they're not all scheduled to be there in May at this point because the in-person hearing has been canceled because of COVID-19. The DCA hearing room, DCA itself is actually not open to the public at this point, or wouldn't be open to petitioners or board members actually at this point in May. So there is no May hearing scheduled at this time.
I'm sorry, so we canceled it before this vote.
This vote isn't paramount to whether the hearing was going to be held. This vote doesn't determine whether the hearing is held. The COVID-19 situation determines that.
Well, again, that was on the petition hearing matrix. One of the options was to hold a hearing as scheduled.
If we knew that the hearing was going to be available at that time, which we don't know.
Okay, thank you.
Thank you.
So this is Dawn. I have another question now. So, what are the if we were to say no, then what are our options? Right now, there's a recommendation to accept what came out of committee, but what are the alternatives?
Our only option aside from this option, is that we reschedule everyone so that the 7 petitioners in this cohort become the August cohort. The August cohort becomes the November cohort, and so on and so forth.
If there is an August hearing.
And that's dependent on the idea of that if we are allowed to have an August meeting, because frankly, we have no idea, we have no guarantee that the whole shelter in place will be lifted, that people will be able or willing to travel, especially in a plane, that we will have meeting space at DCA or elsewhere. Essentially, we don't have any indication yet. We don't think we will probably for another 6 weeks, maybe a month, maybe less, of what can happen in August.
So I understand that, but I have to say, I am working remotely from home, and I spend 6 hours a day doing meetings with people from all over the state we do them via either Microsoft Teams or we do them via Zoom, so that we are all able to interact and see each other. And so is there no option for the hearings to be held that way?
We don't believe that there are options aside from those.
Okay. All right.
Thank you. John, do you have any questions or comments?
No, I do not. I'm very comfortable with the proposal that came from the committee.
Thank you. Carol, do you have any questions or comments?
Nope, I'm also comfortable with the proposal.
Donna, do you have any further questions or comments?
No, I mean, I'm not as comfortable with the proposal, but I think I understand it, so.
Okay, thank you. Paul, do you have any questions or comments?
No, thank you. No further questions or comments.
Thank you. Melissa, do you have any questions or comments?
I just have a question in regards to the backlog. What does that currently look like right now?
Jay, if you could answer that.
2021.
At this point, any point applying right now for a hearing would be scheduled for May of 2021.
Okay, so yeah, postponing it would be kind of significant. Okay, thank you so much.
Thank you, Melissa. Cheryl, do you have any further questions or comments?
No, I do not. Not comfortable.
Thank you. Ken, did you have anything you wanted to add or any further comments?
No, just a comment. I understand that this is not an ideal situation, and not something that I would prefer. But I think because of the circumstances that we're under, it is a time where we have to do what we can do as fairly as possible, but also give that opportunity for those to be able to move through so they can get their license and go to work as we hope they can do.
Thank you. Is there any further questions or any further comments from legal counsel or staff?
This is Ken Swenson. I can repeat the motion because I think I heard during the earlier discussion that some of the members had trouble downloading the document. They had it. So the motion coming out of committee is as follows. The motion was to recommend to the full board that the May 2020 petition hearings be referred to the Office of Administrative Hearings for hearing before an administrative law judge. Thank you.
Thank you. Is there any public comment? If you wish to comment on the agenda item, please send an email to the email address bvmptboard@dca.ca.gov. Elaine, are there any comments or questions from the general public?
Not on this agenda item, Madam President.
Thank you. So it has been moved from the committee, so it requires no second. The recommendation is to move the petitioner hearings for May 2020 to the Office of Administrative Hearings for to be held before an ALJ. Paula?
I'm a yes.
Bernice?
Abstain.
Alita?
Very reluctantly, yes.
John?
Yes.
Ken?
Yes.
Carol?
Yes.
Donna?
Yes.
Paul?
Yes.
Melissa?
Yes.
Cheryl?
No.
And I'm a yes. Thank you. Motion carries. 9 yes. 1 no, and 1 abstain. Thank you.
Hi, Tammy. This is Paula Amazola.
Yes, Paula.
I was wondering if we will be able to discuss other options in case August we are still sheltering home. So before we end this meeting, if we can talk about options so that we have alternative options than just this one recommendation for August. I just want to have a plan where all board members feel comfortable. Thank you.
I agree, but I'm not. Ken?
Yeah, this is Ken Swenson. The agenda only provides for a discussion and possible action relating to the May 2020 board meeting, since it is a special meeting. That matter, however, can be taken up at the next regular board meeting.
So, Elaine, is it possible to add that on the May board agenda so that we have full board's input in regard to August meeting and that we're still in shelter in place?
Madam President, of course that's possible. And as you know, we would always have that agenda item at the very end of the meeting of suggestions for further items. I would suggest that the executive committee discuss this at their May 8 meeting as well, and then have some further discussion at the May board meeting.
Thank you. So that brings us to the agenda item 6B for discussion and possible action regarding the May 21 to 22, 2020 board meeting. The executive committee discussed the format for the May meeting on Friday, April 17th, and the plans to utilize the WebEx platform for the May 22, 2020 board meeting. The platform is more accessible than the teleconference platform that we currently use with webcasts running simultaneously. It allows for more participation from stakeholders such as the schools. Elaine, if you could provide additional information.
Actually, I think that summed it up quite nicely. The only discussion I was going to offer, of course, was that the success of a meeting held via the WebEx platform depends very, very heavily on the preparation for it. By that, I mean that the scripting must be followed scrupulously, and the department, information services, recommends that the board members themselves engage in something of a dry run, not just once but twice, to get the feel of how that meeting proceeds and how that environment looks. The department is very, very happy to convene those at the convenience. Staff is very happy to do so in the evenings if need be. And that also includes a smaller meeting just with the president and or vice president to get the feel of chairing that meeting.
Thank you, Elaine. I know, I believe it was last week when the BRN held their board meeting. I was able to log on because I wanted to see what this WebEx meeting was and how it ran. So I logged into it when the BRN had their meeting. It was interesting. I know the BRN was able to, although you couldn't see people as you do like in a Zoom meeting, they had a portion of the screen that said who was on the WebEx meeting, and then on the other portion of it, they had the agenda item on the for people to view. So you knew what agenda they were on, and it you could kind of see who was talking. because the moderator would unmute that person's microphone so they can talk. In the beginning, when they got started, it was a little rough, but once they got the meeting going, it seemed to work nicely. So I myself would prefer some sort of video conferencing system, but seeing how that currently is not an option for us, it seems to be the WebEx would be the next platform that would be available to us, and it would allow us to have the most participants possible for our board meeting. So I'll ask for questions from the board. Paula, do you have any questions or comments for this?
I have only to say that I agree that we should do a dry run before May to test the equipment and to test audio and call information. But other than that, I think it's a good idea.
Thank you, Paula. Bernice?
I'm in agreement, and it is a good idea, I believe.
Thank you. Alita?
No question.
John?
No questions.
Ken?
No questions.
Carol?
No questions.
Donna?
No question.
Paul?
I have a comment. I guess I'm just a little dismayed and a little exasperated right now that we just said that it was technically impossible to have a hearing via teleconference or WebEx, and now we just simply are going to the next agenda item where we're going to schedule a teleconference or a WebEx. I find that completely inconsistent.
Thank you, Paul. Elaine, do you have any response to Paul's comment?
Not specifically, though. I would point out that the entire Cisco system failed. Actually, the whole Western Coast connected through Cisco failed during the BRN's meetings, and to subject something as sensitive as the hearings to that uncertainty, I think would do a great disservice to the petitioners.
I can appreciate that. Thank you for your response.
Thank you, Elaine, and thank you, Paul. Melissa, do you have any questions or comments?
Yeah, I have a question. The WebEx equipment, is that the same one that you guys just recently used on April 20th with the committee meeting?
No, that was a different system altogether. That's actually much more akin to the system we're using right now.
Okay. All right. Yeah, because it was really kind of glitchy trying to watch it today and trying to listen. And so I was just wondering if it was the same equipment. But thank you so much.
Thank you, Melissa. Cheryl, do you have any questions or comments?
No, just want to echo what Paul, Mr. Sellers said, and other than that, no.
Thank you. Is there any comments or discussion from legal counsel?
Ken Swenson, nothing for me this time.
Thank you. Ken, I do have a question. This requires a motion from the board, correct?
That's correct.
So this is Donna. I guess I do have a question. Sorry if I can still ask.
Oh,
'Cause
yes, definitely, Donna.
Yeah, it was, I guess it's, my assumption, like my brain is still stuck on sending all of the May hearings to the ALJs. And then I guess I really was thinking that unless there was something that we needed to have, we wouldn't even be having a May board meeting. And then we jumped right into, well, we're going to have a 1 day May board meeting, a 2 day May board meeting. And so then I thought, well, we'll do that telephonically, which we can't do hearings telephonically. So I kind of get that, but then to jump right into, oh, well, we're going to do that one via WebEx, I guess we did too much jumping. So what are we going to do during the May board meeting?
This is Elaine again. Are you suggesting that canceling the May board meeting would be a good option at this point?
I'm not really suggesting anything. I think my brain is trying to catch up with everything, just like Paul and Cheryl's, that we just said we can't do the hearings, and I think that we all don't like it, but regrettably we understand the need to do that. And then I guess I didn't correlate the WebEx portion to the May board meeting because I am not a tech genius, but today we're just doing a telephonic meeting, correct?
That's correct.
Okay, there's no WebEx, there's nothing. There's nothing for anybody to log on to, there's nothing.
Well, technically this is being webcast, which means that you can log on to the internet and hear the audio of this meeting. Although there have been a number,
So there are glitches. So what would be the benefit of doing the WebEx meeting? Is that because we can see if you can share a screen on a WebEx and you can see documents? Is that why you would move to doing a WebEx meeting for the May meeting?
It's a much more stable platform. It's a one platform rather than using the phones. And up to 1,000 people could be participating in the meeting, as opposed to the 20 that we would be limited to in the platform we're using right now.
Okay. And so then why wouldn't we do a WebEx reinstatement?
We actually don't have the ability to guarantee that the petitioners would be able to access it.
Okay. All right. I'm sorry, it does seem like we're saying a number of different things here. I guess it almost seems like it'd be better to not have a meeting than to have a meeting that is broken up and you can't really hear. But that's just my personal opinion.
I would actually agree with that, except for the fact that what we're proposing for the May board meeting is actually a very much abbreviated 1 day meeting, the Friday of the board meeting itself, and doing the very basic necessities, the approving the reports, looking at finance, and possibly some legislation. But it would not be that multi-day meeting that you're used to. It would be just the essential business.
Okay. And then we did the Education Practice Committee via Teams, correct?
No, it was the format we're using today.
We used that one. What did I do via Teams? I did something. Oh, I know what it was. We did the ventilator discussion via Teams.
That's correct.
Okay. All right. All these meetings get rolled into one. Okay. Thank you.
Thank you. So
So do we need a motion?
Yeah.
You do, Madam President.
So do we need a motion to hold the abbreviated May board meeting via WebEx? Is that correct?
That is correct.
I'll make that motion.
John Deerking will second.
Thank you. So the motion is to hold an abbreviated May board meeting via WebEx, made by Donna, seconded by John. Do any board members need further discussion or questions on this? Paula?
The only discussion is that I hear our board members comment about making one type of meeting platform available for hearings, in addition to board member board business, and I think moving forward, we should definitely be asking the petitioners if they have access to internet and a laptop to join these types of meetings. And we need to do everything possible that we can to ensure that our August meeting could, we can get these different items sorted out. And so that's where my mind is at. No other comments.
Thank you, Paula. Bernice? Bernice, did you have any questions or comments?
I'm sorry. Can you hear me now?
Yes, I can hear you now.
Okay. No further questions or comments at this time.
Thank you. Alita?
No questions or comments.
John?
No, I have no questions. Thank you.
Thank you. Ken?
No, not for me.
Carol?
No comments or questions. Thank you.
Thank you. Donna?
No comments or questions.
Paul?
No, thank you.
Melissa?
No questions or comments. Thanks.
Thank you. Cheryl?
No questions or comments.
Thank you. Is there any public comment? If you wish to comment on the agenda item, please send an email to the BVMPT board at dca.ca.gov. Elaine, is there any?
No, Madam President, there has been no questions or comments on this item.
Thank you. We'll do a roll call vote, and the motion is to hold an abbreviated May board meeting via WebEx. Paula?
Yes.
Bernice?
Yes.
Alita?
Yes.
John?
Yes.
Ken?
Yeah.
Carol?
Yes.
Donna?
Yes.
Paul?
Yes.
Melissa?
Yes.
Cheryl?
Yes.
And I am a yes. So motion carries. That brings us to agenda item 7. Any public comment that is not on items not on the agenda. The committee may not discuss or take any actions on any item raised during this public comment section except to decide whether to place the matter on the agenda of a future meeting. I will now ask board staff if they received any emails or comments or questions, and read the comments or questions, please.
Madam President, we have one comment sent from Tracy Trong. I will read this verbatim. Hi, I am a current first semester LVN student, and we have not been getting updates about our clinical hours. So far, no decision has been made, and we are stuck on what else to do. Please address the situation with all LVN programs in regard to our next plan to move forward. Thanks, and stay safe and healthy. Best regards, Tracy.
Ken, can we ask that, because I know the education committee and the education department is currently working with schools, but how can we, or are we able to place something on the website that the students can go to help get some reference or where to ask questions to about this?
It's possible to add that to the website. With regard to this particular agenda item, since the question is not germane to anything that's an action item on the agenda, it can't be discussed, but it can be placed on a future agenda for discussion and update.
Okay, and
Ken, this is Paula Amazola. Can we instruct staff to put something on the site, or we can't do that also?
No action can be taken in response to the public comment. It can only be added to an agenda for future discussion and action.
Okay. And do we need a motion to add that, or can I just request it to be added to May?
It can simply be by request.
Okay. Elaine, if we could get an update on that at the May board meeting?
Certainly, Madam President.
And thank you. Thank you for that comment, Tracy. Paula, do you have any comment or agenda item for a future meeting?
Yes, I would like, I understand that these are very difficult times that we're living through, and there's lots of firsts that we are experiencing and lots of lessons we need to learn. But I would like to ask the staff in the May meeting if they can report which of the petitioners for August can do a WebEx. Basically, do they have access to a phone, internet, or laptop so that they can join the August meeting via WebEx?
Thank you, Paula. Bernice, do you have any comments or agenda item for the future agenda or future meeting?
One would be the training, and while we have said we need to do WebEx, I'm actually suggesting that be agendized, so we'll do it.
Okay. Thank you, Bernice. Alita, do you have any questions or future agenda items?
No, thank you.
John, do you have any comments or future agenda items?
No, thank you.
Thank you. Ken, do you have any comments or future agenda items?
No, I don't.
Thank you. Carol, do you have any comments or future agenda items, suggestions?
No, I do not.
Thank you. And Donna, do you have any agenda or future agenda items or comments?
No, I do not.
Thank you. Paul, do you have any future agenda items or comments?
Yeah. I'd like to propose that we add a postmortem or a follow-up on agenda item 6 from today to get an update on both how the hearings are going under the arrangements we made, and then perhaps if we put it late on the agenda, we'll be able to evaluate the effectiveness of WebEx and discuss that in relation to the August meeting.
Thank you. Where am I? Melissa, do you have any?
Yeah, so I was going to ask, I don't know if this could be an agenda item, but what happens when audio connection fails when we put our content up on the YouTube channel? I only asked this because recently watching the Education and Practice Committee meeting, there was some public comments that weren't able to be heard, and people have kind of reached out and kind of asking, is that going to be identified? Like, if there's any other way to correct that? And so I guess, we rely on technology a lot, so just kind of bringing that up on what we can do to get the information out there.
Thank you, Melissa. Thank you. And then for me, I have
Cheryl.
Sorry, Cheryl.
It's okay. So it's not real clear to me to what extent other platforms were investigated. Maybe they were, but I'm just not sure. But I would like to hear about other platforms and whether it's possible for us to use them to conduct our meetings or our petition hearings, if we should have to conduct any more, or if there should be any further delay after the May 2020 meeting. Yeah, that's it.
Thank you, Cheryl. And then if
I'm sorry. This is Paul. She made me realize one more thing. Can we put on the agenda item to discuss how are we handling the appeals, or excuse me, the decisions that were not passed by the board, the cases? I assume those have got to be addressed at some point. You know what I'm talking about, correct? The after-hours closed session.
Paul, it would be the closed session items that we normally handle at the end of the disciplinary hearings, correct?
Correct. Are we gonna include those in the April meeting?
In the May meeting, as far as I know, from what I have been told, we have 2 closed session items from, I believe it's from our mail ballot packet. Am I correct, Jay?
Yes, there are 2 closed session cases to be discussed.
And that'll be included in that meeting?
I believe Ken Swenson? I believe they will be included at the end of the May board meeting. Is that correct?
That's the plan.
Thank you.
Thank you.
This
Thank
is Donna.
you, Paul.
How do we ensure a closed session when we have a number that people can call into?
We don't give out that number.
So we would all hang up and then dial a different number?
That's correct.
Okay, thank you.
Thank you. And one of my suggestions for future or for a future agenda item, and this goes along with where Paul and Paula were talking about, as far as in the future, for let's say the August meeting, how we're going to handle, if the staff could work on giving us basically information on other platforms that we could use via teleconference or something like a telemed visit, something that we could do where the full board would be able to, along with the ALJ and the petitioner, to hold the August disciplinary hearings in the event that we're still under the shelter in place.
I'm sorry, were you waiting for a response from me, Madam President?
Well, I just wanted to acknowledge that that would be done so that they can report back at the May meeting or send the information out.
We will certainly provide that information.
Thank you. And I think we did agenda item 8 with 7 for suggestions for future agenda items. And I'll ask the board staff if they have any other email comments or questions.
No, Madam President, nothing else has come in.
And do any other board members have any future suggestions? Paula?
No, I'm good, thank you.
Bernice?
No feathers. Thank you.
Alita?
No, thank you.
John?
No, thank you.
Ken?
Nothing from me.
Carol?
No, thank you.
Donna?
No, thank you.
Paul?
Nothing further. Thank you.
Melissa?
No, thank you.
Cheryl?
Yes, there is one point. Did we already address, my mind went blank on it, but how the clinicals are working? I know education touched on it during our meeting, how clinicals are being conducted now that we have shelter in place, and how that impacts our students trying to graduate when we need them out in the field, trained and ready and licensed.
If I could, since that was a question posed to us by the general public, that will be put on the appropriate agendas.
Okay. Okay, thank you. That's good.
Thank you, Elaine.
This is Donna. Sorry, this is Donna. I have a question related. It's kind of related to that too. Didn't that question come up during the education and practice as well?
Yes.
Or am I getting all the meetings confused again?
Yeah, I said that.
Yes,
Yeah,
the issue came up during education and practice. Our limitation today in addressing it is it's not agendized for the special meeting, so it'd have to be put on a future agenda.
Okay. Okay. All right. I just wanted to make sure that it has already come up once. So what was, that's all right. Never mind. Thank you.
Thank you, Donna. That brings us to agenda item 9. Before we adjourn, I want to thank everybody for being on the call and forgiving me for the mishaps, I guess. I missed a few things, but I want to thank everybody for their hard work and time put in. So we will adjourn this meeting at 3:21. Thank you, everybody.
Thank you.
Thank you.
Thank you. Bye, everybody.
Thank you, Madam. Thank you, everybody.
Thanks, everyone.
Bye.
Thank you.